Okay. Okay, why don't we try to all sit down, please? Jerry has commanded that we shall start no later than 15 minutes behind schedule. So to do that, I'd like to, great, okay. First, personally, I would like to thank Jerry and Keith, of course, for bringing this phenomenal crowd together to address such a broad range of issues in this terribly important domain, and of course, our hosts here at Duke Law School. With that, I'd like to say that we have just a terrific set of papers in this third session of the conference, one by John Barton, another by Pam Samuelson and Suzanne Scotchmer, and a third presentation by Tim Swanson, and we'll be hearing as well as a discussant from Bill Kingston, and then myself, notwithstanding the incentive incompatibility between being a chair, keeping time, and a speaker. But I'll let that play out as it will. Okay. With that, and to spare time, I'd like to then introduce first John Barton from Stanford, who will speak about nothing less than a world patent system.
I decided that wasn't ambitious enough. And so I want to expand my presentation a little bit beyond the paper. Now, more seriously, I want to pick up on one of Bob Cohen's points this morning, or sort of add to it, and say there's another strategy, and it's divide and conquer. And suggest part of our problem is, in fact, that patent lawyers are the ones that have been shaping patent law. There are a lot of other interested parties. And the point in which I'm going to expand and goes beyond a paper, and in fact goes on a different project I'm working, in fact, with Pedro on, we'll be talking about in Geneva next week, is maybe if we got a different constituency in, we could begin getting some different results. And what is the constituency for the scientific commons? It is scientists and significant chunks of industry. Is there a way, and I will stop at this point and be happy to discuss it afterwards in questions, is there a way that you could, in essence, get a WTO code designed to open the scientific commons on and maintain it open on a reciprocal basis, the same way we get the benefits of free trade on a reciprocal basis? And a way that you could, in essence, have, for this technology transfer scientific commons code, that you could, in essence, have participation of scientists, engineers, et cetera, saying, how can we get one more step, this round of negotiations, how can we get one more step towards strengthening the global commons? All right, with that, let me turn to the slightly less ambitious one, the world patent system. Actually, I don't think it's as ambitious as it sounds. I think it probably is going to happen. And let me describe how I think it's going to happen. I think it's going to happen not because of TRIPS, but because of WIPO. Right now, there are patent harmonization negotiations going on at WIPO, whose goal is fundamentally to create a set of common standards for a patent, such that the US and the European, and presumably the Japanese patent offices, can effectively not only search for each other, but decide for each other. Now, maybe it's various kinds of review and all that kind of stuff, but we're moving to that. And the pressure, simply the costs of maintaining the patent system, maintaining the patent offices, and the cost of the duplication of patent searching in face of the increasing number of applications is pushing us to that. Now, between the US and the EU, is that a global patent system? Of course not. But just simply visualize whether or not in the Free Trade Agreement of the Americas, revisions of 2010, there will not be a provision requesting that everybody sign up to precisely the same patent standards that are currently being negotiated at WIPO. In other words, we really are moving towards an international system. There is such a system in Europe already. What is not international at this point is the enforcement process. And there are some good technical reasons for that. But I have every reason to believe that after we get some harmonization of standards, we may move to enforcement. Now, I have to own up. The move to enforcement in Europe has not been easy. Negotiations on moving to some version of the European Patent Convention plus some kind of European Union directive which would amount to harmonized regional enforcement within the European Union. Those negotiations have been followed up on things like language. One of the, understandably, political set of issues. One of the things I really don't know, but maybe, is whether or not that language barrier is really simply the surface barrier for people saying, we don't want to make those changes anyway. It may be, it may not, I don't know. So what I want to suggest with that background is there is significant effort underway which very readily could lead us to a world patent system. I can't guarantee that it's going to happen politically, but it certainly is plausible. It's not at all implausible. Now, if you look at that and you ask yourself, issues of today's meeting, what's going to happen in the developing world as a result? You panic. Because one of the things which you still have in the developing world, unless you've given it away in bilateral negotiations, is you still have the freedom of TRIPS. And of course, I know a lot of people say TRIPS doesn't give you that much freedom, but it gives you a heck of a lot more freedom than a uniform global patent system would. So the issue I have really set for myself and that I wanted to present in the paper is, suppose we had a global patent system that made sense from the developing country perspective. What would it look like? And then at the end, I'll hit you with the political question of the choice between that and other alternatives. Now, I think there's two fundamental sets of issues that the developing countries have to be concerned about in the design of such a system, to begin with. I mean, so there's two fundamental sets of legal issues. One is the problem of the commons, public goods, research tools, the problems which I know we're going to be having some more sessions on, but fundamentally, the question of whether or not all, and the ones which I already talked about this morning very significantly, the questions of whether or not all those little incremental patents make research a nightmare, such that research for the developing countries won't be doable. All right, we have a set of tools within the patent system which, won't necessarily solve the problem, but can help. And putting those tools in would mean that this global patent system has to have at least the following kinds of standards. One, a significantly strong non-obviousness or inventive step standard, so we don't have patents on irrelevant inventions that simply are blocking entities rather than real contributions. Two, some kind of utility standard, such that we don't provide patents on basic scientific inventions, but do provide patents on things that look more like application. And three, some kind of strong research exemption, such that thickets of patents don't significantly complicate research. Now note, the first two of those are patent standards, which are relevant, in fact, in the treaty which is being negotiated at WIPO right now. The other one, the research exemption, is something which is going to happen, which hasn't been faced yet in these kinds of contexts, but is going to have to be faced sooner or later when we actually have treaties governing international patent enforcement. All right, the second problem, so step one is you put the kinds of specific technical patent rules that I'm describing into your treaty. Now, it's not at all clear to me that they're going to come out of the WIPO negotiations. I have a strong feeling that the WIPO negotiations are going to lead to an agreement that defines a patent standard a heck of a lot closer to that of the current United States standard, which I think would be a mistake. All right, the second question you need to think about from the developing world perspective is the question of drugs, what's going to be the second session this afternoon. And drugs, of course, are fundamentally, probably the leading example, but there may well be other examples. It does not seem fair to charge to the developing world consumer the same chunk of price that you charge to the developed world consumer to pay for the development costs of producing a new drug. In other words, we clearly need a differential, at least in my judgment, a differential pricing kind of system in which the developed world consumer pays for those new research costs, the developing world consumer gets the product at something much closer to marginal cost. In order to Ramsey pricing, the economics of price discrimination in the different markets, does not get you there. Because it deals, in fact, with price elasticity. The difference between the developed and the developing world is not so much price elasticity in this area, it's fundamental ability to pay. Therefore, you need the kind of genuine and real benevolence from the pharmaceutical industry that we are seeing in many cases, in particular in sub-Saharan Africa, right now, of the arrangements which are being negotiated to provide drugs at lower cost. Yet, I think it would be foolish to rely on benevolence. There needs to be some kind of mechanism to make sure that benevolence will remain through hard economic times. And that ultimately means something like a compulsory license. And you therefore need your global system to have a compulsory license kind of arrangement, or it would be very unreasonable for developing nations. I might note, by the way, there are actually two conflicting draft treaties that are being developed in, well, there's one that's being developed by the European Patent Organization, and one being developed by the European Union Commission to deal with Europe and to deal with intra-Europe enforcement harmonization. One of those has compulsory licensing provisions in it, and the other one does not. Okay, now, if you can, in other words, in my suggestion, if you can get a world patent system that has those special arrangements in it for the developing world, you're in pretty good shape. Now, what are the other things that you need to think about in order to make that kind of international treaty work? First of all, what happens to patent offices? European Patent Organization's basic strategy has been, let's develop a European patent, and then sooner or later, and as a patent parallel to national patents, and then sooner or later, the national patent officers will wither. And maybe in the meantime, we'll benefit from some competition. Not bad. The other option is, in some way or another, you make existing patent offices into specialized subunits of a global patent office. Alexandria, I should point that way now, Alexandria reviews software patents. Munich reviews biotech patents. Brasilia, or it's actually down in Rio de Janeiro, reviews hardware patents. Right. Obviously, you work towards that and you negotiate and you have to deal with the capabilities of the individuals in each place. But there clearly are ways that you can deal with the understandable bureaucratic concerns of each of these entities. And still, at the same time, save significant cost. My rough calculation of the cost saved by a global system is on the order of $1.5 billion, simply in terms of filing fees. Now, that's, I haven't done a calculation which gets me into legal costs, or differential legal costs or anything of that type. And in a sense, it's not a heck of a lot of money, but it's something. Now, if I'm going to have patent offices around the world and going to have uniformity, I'm going to need some kind of review process. So it's going to have to be something ultimately like an International Court of Appeals for the Federal Circuit. I'll come back to that. It is unavoidable, however. I mean, there is no way to take the two most important decisions. There is no way that people can reasonably trust a patent decision to be made by a set of offices in situations in which, at least traditionally, some offices are extremely weak. There's no way we're going to do that without some kind of global procedure, which probably means an appellate court and an appellate court, realistically, in order to decide whether or not the patent should be issued. Similarly, and this is an issue which has been mattered in the European negotiations as well, there's no way that, I'll blame Europe, that a patent holder in the United States, is going to accept a decision of patent invalidity coming out of a court in Europe. Period. No. We therefore, but on the other hand, there's no sense in the system if we don't have a court somewhere that can say a patent is valid or invalid. Therefore, there's going to have to be an appellate process for that. So I need a global CIFC. I'll come back to that. A couple of other, one more issue which I think needs clearly to be faced, and more at the technical level before I get to the final political kinds of questions. At the technical level, very technical, is exhaustion. Theoretically, if I have a global patent, I have global exhaustion. I mean, simply as a matter of logical theory. On the other hand, I think it is absolutely crucial that we have a way to maintain that price discrimination between developed and developing country drugs. The patent system is one way to do this. Therefore, you really need some very careful definition that says, in general, global exhaustion, because part of the idea is we don't anymore want people to be able to use patent games to prevent Adam Smith-style optimizing movement of goods from one country to another. But we sure in the world do want certain goods to be price differentiable between developed and developing countries, with pharmaceuticals being an obvious example. So you need an exhaustion system which says, in general, global exhaustion, but there's going to be some important exceptions, i.e. pharmaceuticals, and you need a set of standards for those exceptions. Now, let me turn to the more political issues, looking at the clock. Do we want a global CAFC? And I would say that for the people in this room, certainly for me, the answer is certainly not. There is a real problem in there. How do I deal with that problem? And I think the answer of how I have to deal with that problem is to create some kind of review process in which my beginning thinking is to model it on the kind of conference of the parties process that has emerged in environmental negotiations. That I have a conference of the parties which meets regularly, which has working for it some committees which do serious expert kind of work and serious econometric analysis and everything like that to tell us how well the global patent system is working. I think we need that in any event, by the way. But and also can regularly say, boy, our global CAFC really blew it on the patentability of business methods. Why don't we have a commission that's going to study the patentability of business methods and report back to us, and the conference of the parties can decide whether to change the rules for the patentability of business methods in a treaty amendment kind of procedure. In other words, I need some kind of political master of this international technical operation. Not only do I need it because of the risk that the patent lawyers who will dominate the technical operation may get it wrong, I also need it because this very entity is going to be one that I am going to significantly lose international political control over simply because of its economics. Consider that the economics of WIPO is 85% of its income comes from PCT filing fees. 15% of its income comes from national governments. In other words, it has a space for autonomy that almost any other international organization lacks. Now, that's not all bad. It's both good and bad. But this new patent system is certainly going to have that kind of autonomy. How do I manage it? I clearly have to manage it by making the kind of political review process that I described strong. Now, I haven't filled in this context yet, the divide and conquer point. And the divide and conquer point has to be that the representatives to this international review process are not patent lawyers. They've got to come not from, because there won't even be national patent organizations anymore, at least after some significant transition period. Those representatives have to come from ministries of science, ministries of commerce, ministries of trade, ministries of development. In other words, I want to make sure that that supervisory organization is one which reflects a set of concerns that are different from those of traditional patent law and keeps patent law in an instrumental fashion. This means, by the way, that if WIPO becomes that organization, which is not inconceivable, that the way the representatives to WIPO are, to the WIPO General Assembly, I forget what his technical name is, the ways those representatives are chosen has to change and evolve. Okay, so you can see what I mean when I say divide and conquer. Take advantage of the fact that there are different groups within nations that want to achieve different things in the patent systems, and see if we can't build on that fact somehow in trying to shape this whole process for the better. Now, the final political question, and of course it depends on my first judgment here, where is this current patent harmonization process going? My final question is, how can the developing world try to ensure that if we have a global system, it will be a global system with the trade-offs that I've described, which are probably not against the interests of the pharmaceutical companies very much, maybe against the interests of the biotech companies because of the research tool question, but fundamentally are a set of balances that many reasonable people, including the pharmaceutical industry, would probably accept in terms of patent standards and compulsory license. How can we make sure that it's that system rather than one that is based on the incremental effective extension of the U.S. patent standards, which I think is the likely result of the WIPO negotiations as they're standing? I think that's going to be the hard political question.
Good. John, thank you very much. Very, very intriguing, and we'll be hearing more about this. And the next paper will be presented by both Pam Samuelson and Suzanne Scotchmer, and we'll be hearing about intellectual property rights for information technologies.
Magic. Thank you. Well, this John's paper is about the unification of the international patent system, whereas what Pam and I have been thinking about and want to talk about is the ways in which the latitude for national differences has an impact that goes beyond what national jurisdictions think when they make their own intellectual property laws. So we've entitled our paper Intellectual Property Arbitrage: How Foreign Rules Affect Domestic Protections. What do I aim this at?
High up there.
There, right.
Okay.
Do it?
There you go.
Okay, so let me, this first slide just sets the stage for thinking about this. One can think about, of course, intellectual property as being all about protections, but one can also think about it as being limitations on protections. So, of course, intellectual property rights aren't absolute. And they're limited. Oh, this is the wrong slide. One back. Yes, sorry. They're not absolute. One can think about the ways in which they're limited, and ones that, of course, are quite familiar, certainly to both economists and lawyers, is that we limit intellectual property as to length, to breadth, to exemptions, limitations that vary internationally. But the one that leaps to mind when one is thinking about the international context is, of course, geography. And that's because, as Pam will say more about, that's because under the current system, TRIPS, the International System of Treaties, there is a lot of national liberty to choose national rules, differentiated rules, thereby limiting or expanding intellectual property rights as to geography. American rules are different than European rules and Japanese rules, for example. Notice that except for sui generis laws, as for databases or semiconductors, these limitations are in general not subject matter specific. That is, copyrights and patents cover a lot of subject matters. And that creates a certain constraint in and of itself that is important here, although I won't say very much about it. Okay, so how do geographic limitations work under the system of treaties that we have in place? The first observation I want to make, which comes simply from the provision of national treatment of foreign inventors, is that the most natural way of limiting protections geographically that would naturally spring to most people's minds is impossible. So the most natural limitation you might think of making geographically would be to say American inventors are protected in America and their inventions then become available abroad for competitive supply, and European inventions are protected in Europe and they become available abroad for competitive supply. That is, that domestic inventors are protected domestically but not abroad. Maybe that's all the protection they need, and that would be a sensible system of what I call here on the slide reciprocal externalities. If regions are more or less the same size, that might make sense. That is precisely what is excluded by national treatment of foreign inventors. Precisely, that is what is excluded. That is impossible to have those kinds of reciprocal externalities, to limit geographically intellectual property rights in that way. And so what happens instead, of course, is that, if a particular subject matter is protected in Europe, then it's protected for American inventors as for European inventors. That's what national treatment of foreign inventors means. And so if one jurisdiction chose to withdraw from that kind of strong protection, they couldn't withdraw only on behalf of their own inventors or anyone else. They would be withdrawing on behalf of all inventors everywhere. Okay, the other observation we want to make about geographic limitations is that the system creates a certain kind of asymmetry between private inventors and public sponsors, the incentives of private inventors and the incentives of public sponsors of R&D. Something we forget, and I think economists are far more forgetful of this than lawyers, is that in the modern innovation system, most innovation does not take place in the private sector. About half of it takes place in the public sector, except in the US, where there's been a reversal in the last half of the 20th century, which it used to be more than half in the public sector circa 1950. It's now more than half in the private sector. But everywhere else in the world, about half of R&D spending is public, and that makes this an interesting question. Notice that the other consequence of the geographic context, the international context, private inventors have the same incentives to invent, that is, a private firm has the same incentives to invent, regardless of where that firm is domiciled. That's the other feature of national treatment of foreign inventors. So a Japanese inventor has faces exactly the same rights globally as an American inventor, even if, with respect to that subject matter at hand for that firm, even if Japanese and American law is different. That's because of national treatment of foreign inventors. That's not true. So it doesn't matter where the inventor is domiciled if you want to look at incentives. And by the way, that wreaks havoc with the empirical exercise of trying to figure out what's a better incentive system because of that, simply. Public sponsors, on the other hand, have different incentives depending on how they're motivated. The assumption here is private firms are motivated by profit. Well, we don't quite know what public sponsors are motivated by, but as John Barton has already stressed, we don't have in place the same well-conceived notion of how to mediate between the public and public sponsors and users as we do for the private sector. So that's not really the subject of our paper, but it's part of the context that we view as important here. Okay, the international context shifts the balance between the private and public sectors in ways that are important, especially if you think that the public sector ought to be more important, as I think this conference, for the most part, takes as its premise. So suppose a country is considering protection for a particular subject matter. Which of the following two does a country prefer for that subject matter? So there are subject matters that we give over to the competency of the public sector, and there are others we give over to the competency of the private sector. So which will a country prefer? Will it prefer to have that subject matter protected in a harmonized way under TRIPS, or will it protect public sponsorship? How will it make that decision? Well, for harmonized protection, the country, notice what you get if you manage to convince the world to harmonize on that subject matter and you have a lot of inventors for that subject matter. What that gives you is the right to repatriate benefits that would otherwise be given by your domestic inventors to the rest of the world as externalities. You get to repatriate benefits as profit. That's what harmonization gets you. It's a powerful incentive. So you can ask questions then about that, whether the incentive to argue for harmonized protections is too strong or too weak, and work through, as I have here, but I can see I'm already overrunning my time, and won't, what kinds of countries are more likely to argue for harmonized protections as opposed to, for example, public sponsorship. Okay. Okay, so what Pam and I want to stress in this paper, which isn't written yet, is that in this context, but Pam is going to tell you what the paper will say, in this context of international protections and national treatment, where some subject matters have been harmonized on and some have not, that allows a lot of scope for national differences. When that scope for national differences is exercised, not only with respect to formal rights, but also with respect to collateral rights such as contract enforcement, what do the differences among regions do for domestic protections and foreign protections when these differences exist. So that's our topic. This one makes it go forward, backward, and I can't remember what the other one does.
Okay, so to sort of finish the sentence of the nations can grant different protections, the end of that sentence should be that the assumption is that if you grant, for example, a higher form of protection in the United States, that the assumption is that the U.S. developers of whatever the subject matter is will be able to benefit by the higher protection in the United States, and that things that happen elsewhere won't undermine that. And what we're interested in is some examples. What we're interested in is a set of examples where differences in national rules actually may not only have an effect in the sense that there will be these externalities that will be beneficial to other countries because they'll be able to enjoy as a public good things that are not protected in their country, even if it was in the United States it would be protected subject matter. But we're interested in a couple of examples where differences in national rules actually then may have implications for the ability to do domestic protection through the higher protectionist rule. And so these are the set of examples that we want to try to play with. And we were assigned by Jerry to talk about information technology, and we started talking about these examples. We think the point may actually be a more general point than in the information technology field, but our examples right now are of this sort. So one example is, suppose that you have a country, say the United States, in the aftermath of Bowers versus Bay State Technologies, which, talking about the Federal Circuit, it has recently decided that anti-reverse engineering clauses of mass market licenses can be enforced. That actually is a different rule from the rule in the European Union, where at least for interoperability purposes, contracts, whether negotiated or mass market licenses that forbid reverse engineering of software can't be enforced. What is the effect of those differences in the rule? We think that one of the differences may be that what's going to happen is that you go to Europe to do your reverse engineering. You develop a compatible program that doesn't infringe the copyright of the American program, and then because you can, there's no infringing program, you can actually then import the reverse engineered product back into the U.S. market. And it seems to me that that's actually right. The United States has a legitimate right to, let's say, have its rule. Europe has a right to have its rule. But this is a place where the ability to control, even in the United States, to stop reverse engineering and compatibility may be undermined by these differences in national rules. A second example, which actually came out of a proposal that I've seen, that Finland has been thinking about implementing the European Directive on Copyright in the Information Society in terms of anti-circumvention rules. They want to have an exception to allow people to bypass country codes. Many of the countries, especially the Nordic countries, think that country codes are foul things, and that people ought to be able to bypass them. And so they want to create an exception to allow you to bypass for a country code. And so if they do in fact adopt that, and if it's true that, as some cases in the United States indicate, that bypassing a country code in the United States is illegal under U.S. anti-circumvention laws, the question is, what is the difference between those national rules? What are the differences in the impacts of that? And one of them may be that, well, at least in Finland, to the extent that the country code was a scheme for engaging in price discrimination, then at least in Finland, if you can bypass the country code in Finland, then that price discrimination is undermined in that country. But if Finland also allows the Finnish people to post the results on the internet, then even people in other countries, such as the United States, that have a rule that makes bypassing access controls illegal, then may undermine local rules as well. And this actually may help to explain why there has been such a concerted effort recently to try to get all kinds of try to get everybody to agree to U.S. DMCA rules. But this is a place where, if you believe that price discrimination, in fact, is consumer welfare enhancing, this is a place where it's not just a particular protective, or a particular protector, but also consumers might actually have impacts that are not totally good. File sharing is another example. Some of you may know there's a decision in the Netherlands that says that, at least at this point, that peer-to-peer file sharing technology is not contributory copyright infringement. If the United States has a different rule, again, the availability of the internet essentially undermines the domestic protection. We have one other example on research tools. We have 1 minute left. Do you want to say something really fast?
Okay. Research tools are a particularly interesting example. If a research tool is not protected in another country, and it doesn't matter why, either because it's not patentable or you didn't bother to file a patent there only has to be one other country in the world where the research tool is not protected, and all the inventors in the whole world lose their protection. And that's a problem, because that means the domestic rule has no power or no force whatsoever. How does that happen? Well, the research tool can be used with impunity in the non-protected region, and there's no trade rule, unlike for process patents, there's no trade rule that prohibits the new product developed with that research tool from either being patented or sold in the protective jurisdictions. And so so there's no ability to collect royalties on the proceeds of that research tool, and it's as good as not having a patent anywhere in the world.
So here are some of the possible responses. The paper will address them.
Thank you very much, Pam and Suzanne. And I understand that the constraints here are severe, but with that, I'd like to introduce Tim Swanson, who will present his paper, which is co-authored with Timo Goschel, entitled Pests, Pathogens, and Patent Holders, Implications of Biotechnologies for Patent Policies. Tim.
Thanks. In fact, it is co-authored with Timo, but I don't think I'm going to present that after all. I think that...
As a discussant, though.
I know.
That's right.
With apologies. Well, maybe I am.
No, there you go.
With the apologies, I will mention it, but with apologies to AB and discussants, the fact is that I was incredibly unambitious with regards to the canvas on which I painted. We've done a lot of work on biotechnology and IPR and different types of reforms, and I don't think this paper touches anything besides the tip of the iceberg on that. So let me, instead of doing a really nice job of developing that one point, I'll do a fairly sloppy job on three instead. So, and the 3 points I want to do are, and this is the second one, so my discussants don't have to be too worried. Is that with regards to biotechnologies, what I'm talking about for the most part are the life science industries, the health industry, and the plant variety industry, the agricultural industry, agrochemical industry, and in particular I'm talking about the R&D sector within those industries. So that's what we look at, and we have been looking at for the last few years across those two sectors and the importance of undertaking this kind of R&D. Now, I think that with regards to biotechnology sectors, there's 3 really interesting points that we can make about IPR reform, especially at the global level. The first one comes out is a follow-on from what we were hearing this morning about technology transfer and about the idea of low-value activities. Now, there's a particular reason with regards to biotechnologies that it's replete with low-value activities. And that particular reason is that the biological environment is replete with different types of niches. And the environment, therefore, develops different kinds of pests and pathogens, and these different kinds of pests and pathogens are slightly different. The general problem is the same, but the specific manifestation of that problem is a little different everywhere. And because of that, we can wind up with problems with regards to getting R&D that's made to fit all the different places that these problems arise. We wind up with R&D where at the frontier, say with regards to plant varieties, Iowa, the R&D is focused on Iowa's problems with regards to pests and pathogens. Now, with regards to transfer of technology, I myself and I think most economists wouldn't have very much problem with regards to having stronger IPR protection as long as it generated two types of incentives, both the incentive for the innovation frontier to move more rapidly through appropriability, and also the incentive for the dissemination of the information off of the frontier to those countries, those places that are far off of that. Now, one of the reasons that that's difficult in the context of biotechnology is what I said right at the outset, because there are many smaller, diverse manifestations of problems that have to be solved at a fairly local level. Now, to give you an example, we did a study with regards to the F1 hybrid revolution, which occurred in the 1960s, in which a lot of the development of research and development was transferred from the public sector to the private sector with regards to those crops, primarily maize, in which hybridization was possible. Now, hybridization is essentially a use restriction technology. And it meant that it wasn't so much possible for other places to be able to reproduce and use the research that was embodied in it. Now, our research on that found precisely what I was indicating and what was indicated this morning, that the innovation frontier in hybrids moved faster than in non-hybrids, but as you got further off of the hybrids, the catching up process was slower. And so that precisely in this area of biotechnology, we wound up finding that there's a significant problem with the increased, here the use restriction technology, essentially mirroring for our purposes an enforced intellectual property rights system. We wound up seeing the frontier moving more rapidly, but those off the frontier falling further behind, even though the frontier was moving more rapidly. So that's one problem with regards to biotechnology sector. Second thing is this one, which is that the biotechnology sector is scale dependent in terms of the nature of its problems. What that means is that as you solve a problem, sticking with agriculture as the example, as you solve a problem, you also provide signals for the evolution of new problems, so that as you supply research and development in order to, for example, supply pest resistance within a particular type of plant variety. At the same time you do this, if you supply the particular crop on a wide enough level, you're at the same time selecting those pests and pathogens that precisely fit that particular species, that particular crop variety that you've chosen. And so for that reason, biotechnology is an area in which the concept of a technological ladder, where we make progress one step at a time, never going backwards, and always progressing and leaving past innovations irrelevant, is clearly not applicable. It's much more like a technological escalator, where we're both trying to move up the stairs, and the stairs are at the same time moving down underneath us. And it's this resistance problem that's the second fundamental element of the biotechnology sector and with regards to IPR. Now, what's the problem with that with regards to IPR? The problem with that is that the IPR system likewise was developed with this technological ladder concept in mind. The idea that you make all previous technologies irrelevant, obsolete, commercially obsolete, and that you move up and displace and replace all previous technologies. The problem with scale-dependent technological change in this area is that what we would like to see is instead many different technologies in place. So for example, with regards to managing for plant variety depreciation from pests and pathogens, if you plant more and more plant varieties that are slightly different from one another, you don't provide such a clear signal for the evolution of pests and pathogens. It's the same thing with regards to antibiotics, the current problem with regards to multiple resistance of antibiotics. If you used 8 antibiotics in the same hospital, you wouldn't give the signal to the pathogen to evolve into a resistant form. And so the IPR system, again, because it's based on sequential innovation rather than simultaneous and a portfolio-based idea, is again a problem with regards to the basic concept of the IPR system. It doesn't fit very well with the biotechnology sector. Thirdly, and my last point, is to do with the fact that with regards to biotechnology, maybe all of this is going to be irrelevant. The biotechnology industry is definitely as interested in developing biotechnologies for solving the IPR problem as they are for solving production and efficiency problems. And this is something that I think everyone here is aware of. You know about use restriction technologies from F1 hybrids. Well, now the biotechnologies are available in order to extend that to all plant species and animal species. They're not in use yet, but they will be within the next 5 or 10 years. Now, to a large extent, I think that same path is available, and that the private sector will, to some extent, be taking more and more of what we are now talking about in terms of an institutional problem in making it into an industrial pathway in the future. And this is one of the main things that needs to be factored into discussions about institutional industrial change. So those are the 3 things, again, with apologies, that I would rather have said, which are that we've got this importance of the biotechnology having these niches, and the importance of diffusion and technology transfer in this sector especially. Secondly, we need portfolio-based solutions. IPR does not generate that. It focuses on sequential innovation rather than simultaneous use. And then thirdly, this problem with regards to we need to at least be thinking about private sector innovation around the problems we're talking about.
Thank you very much, Tim, and Jerry, we're almost back on schedule with that breakneck speed presentation. And with that, I'd like to introduce William Kingston, who will serve as the first discussant this afternoon.
Well, Jerry, you and I have been talking about the reform of the intellectual property system for a long time, and I'm grateful to you for giving me this opportunity to spread my side of the conversation somewhat wider. Now, this morning, Peter Drahas said something which gave me the cue for the single-line summary of what my standpoint of criticizing these papers is, and it was this. Forget about the deck chairs. The Titanic is not going to be saved by anything except a change of course. That is the position from which I'm starting on this particular thing, and that's why my agenda is for a radical intellectual property reform. And the problem that we're talking about here in this room in relation to intellectual property is a sub-problem of the wider problem of the whole of intellectual property rights. And that is that, as John Stuart Mill said, the laws of property have never yet conformed to the principles on which the institution of private property rests. And our problem is that they're conforming less and less to those principles. And the reason why they're conforming less and less is because of the fact that the laws of property are increasingly being written by interests who are going to benefit by them. And the context of the other values which hold society together is becoming weaker and weaker. We're only talking about one particular aspect of this particular problem. So in the very brief comments that I want to make, I call your attention to the fact that you can see the enormous difference between the philosophical discussion that underlay the United States Patent Act of 1790 and the Act of 1952, which was written by and for the pharmaceutical industry. A perfect example of what I've been talking about. Now, if I rush through, because I want to get onto my agenda for reform without any delay, if I possibly can help, but one of the difficulties that we're up against is the fact that not alone has this system being imposed through TRIPS onto an unwilling world, but it's an inherently flawed system. It is a system which in so many ways has never come to grips with the change from invention, from individual creativity to invention or investment, or from creativity in terms of literature to works done by hire. And we could go on. I could go on indefinitely on that. But let me just move to my agenda for reform. First of all, in terms of, given that TRIPS is, from that standpoint of mine, a bad idea, all we can do is try to mitigate its disadvantages. And one way of mitigating its disadvantages would be money. In other words, there has always been a huge barrier between the aid world, the huge budgets we have for aid, and the intellectual property system. My proposal is, why not use the aid money to buy out the intellectual property that is causing the trouble or going to cause the trouble? If we could even lay our hands upon the bit of the aid money that ends up in numbered accounts in Switzerland, we would have a great deal of money to play with. That would help to deal with the TRIPS problem. The problem of the system's inability to deal with new ways of inventing, new ways of generating information, could be dealt with by proposing to look at the innovation directly, rather than its connection with the invention. And the third one is the one I really want to stress, and that is this. Lord Kelvin in the 19th century, a great British natural scientist, said, "We advance according to the precision of our measures." And that must be true for social science as well as for natural science. One of the difficulties is that we have a system which measures only in terms of time, when in fact what we should be measuring in terms of is money. And therefore I have spent a lot of time working upon a means of bringing a financial dimension into the system, which has a series of advantages in terms of complex technologies and innovation diffusion. And this is where I am enormously attracted by Swanson's insistence of the necessity for parallel developments, what Nelson and Merges call competing trajectories of innovation development, rather than the sequential operation that he's talking about. And as to the world patent of John, I have to say that the Scotchmer paper has in fact criticized that for me, because it does seem that we have to accept the fact that globalization, of which harmonization is a sub-bit, is a Trojan horse. I leave it to you to decide who is the stable master of this horse. But it is a Trojan horse for the poorer countries of the world. And then we come to the question of who is to work for reforms. Well, there was a time, right into the middle of certainly the first third of the 20th century, when we could count upon the bureaucracies of the world to be on the side of right in terms of resisting the activities of interests to develop laws that suited themselves. The bureaucracies are gone, and therefore the only thing left is Jerry's proposal for an academic web of influence, however weak it is. But if my proposal for getting a hold of some of the aid money to buy out the troublesome intellectual property in the poor countries, what better group to administer that money than Jerry's web of influence? Because I've always found that people with money tend to have more influence than people that don't. Thank you very much.
Bill, thank you very much. Okay, I will deal with the incentive incompatibility problem here by appointing John as temporary chair. Okay, very good. First, I'd like to focus my remarks on the Barton and Samuelson Scotchmer papers. With regard to John's, I think he may have a solution to a question that I've had over the past years as I've heard, very persuasive calls to raise the bars of patentability, particularly those associated with novelty and non-obviousness, as well as to modify the utility standard to move IP away from upstream research. Now, I've always had a question with these calls, which, how can that happen? How does that happen? What's the lever? How can that be done in the political and institutional context that in which we find ourselves? Well, he has a solution. Create a new institution, namely a World Patent Office and Patent Enforcement Authority to go with it, which obviously has more objectives behind it than only raising and changing the bars of patentability, but those are surely some of the more important objectives. But then, as I listen to this, and we accept the considerable merits of John's intriguing and visionary proposal, I have a question, the same. And he tries to address this in his remarks, though I think we're, and he would surely acknowledge, a long way from this, which is, how can this proposal be implemented in the political and institutional context in which we find ourselves and the vested interests that surround us? Okay. The Samuelson Scotchmer paper offers an interesting contrast and an obvious one with John's in the context of the proposal for a world patent system. John recognizes the importance and seeming fragility of the public domain by allowing for a very broad and explicit research exemption to patent protection. He didn't speak of that in detail in his presentation, but it's apparent in the paper. In contrast, Samuelson Scotchmer suggests that the existence of distinct national systems actually provides for a broader public domain than may meet the eye and cite particular instances of such. In recent work with Walsh and Aurora on the impact of the patenting and licensing of research tools on biomedical innovation, we also found what one might call a broader effective or de facto public domain than what might have been expected. We found precisely the kind of offshore dodge of domestic IP protection that they speak of. We also found pervasive de facto infringement of research tool intellectual properties, especially among us, academic researchers, the other side of campus, I rather should say. Okay. This infringement has proceeded under a felicitous interpretation of the research exemption that was quite a bit broader than what recent court decisions might have suggested, but we observed a range of behaviors that appeared to advance the interest. This pervasive infringement, it seemed to advance the interest of the public domain and, more importantly, the progress of biomedical innovation. We then wrestled with the question whether the research exemption needed to be made explicit and stronger. This question returns me to John's paper, where he acknowledges the possible challenge of a world patent system for upstream research and accordingly promotes an explicit and broad research exemption. As many in this audience know, actually stipulating an effective and clear research exemption is quite difficult in practice. The devil truly is in the details, and John is fully aware of these difficulties. But John's paper, along with the work of other scholars, many of whom are among you, puts into play the importance of stipulating such an exemption. And indeed, this has gained added force since the Mady v. Duke decision this past October that has effectively disallowed from that exemption research done in universities. It cannot, such research now under this decision cannot qualify. But I have a concern, which is that by explicitly framing an exemption which accepts IP protection as the default, might we achieve the unintended consequence of actually limiting the public domain by undermining the kind of decentralized and informal behaviors and practices that have thrived under a veil of popular, shall we call it, ambiguity. Now, Mady v. Duke may not leave us much choice in the matter, but I would only suggest that as we respond to that challenge, we may want to retain some of the felicitous ambiguity in the law of the status quo ex ante. Regarding Tim Swanson's and Team Gauchel's stream of work, okay, I found intriguing their treatment of what they call a race between innovation and nature in the biological world and the implications of what they call adaptive destruction on nature's part for intellectual property policy. We have before us today, in the form of SARS, an instance in which nature has run out ahead of us in a seemingly proactive form. I would suggest that, however, despite the clear tragedies that have already unfolded and may still eventuate, this event may pose an opportunity. Less developed nations, with their experience with malaria, schistosomiasis, cholera, etc., have long known that a system of biomedical innovation dominated by the exigencies and private incentives of IP protection betrays inefficiencies from a social welfare perspective. It may now be the case that industrialized nations may, in dramatic fashion, confront similar lessons as labs around the world try to isolate the source of SARS and develop some sort of defense. Already, however, we have seen a highly unusual decision on the part of Hong Kong University not to defend their proprietary stake in the discovery of what may well be the source of SARS, namely a mutated form of the coronavirus. This decision sharply contrasts with the protracted wrangling over AIDS diagnostics tests 2 decades ago. The case of SARS may be an instance where we could, and with some urgency should, shore up the public domain in a way that validates and reinforces the behavior of Hong Kong University and makes such behavior more of a norm rather than an exception to current policy, practice, and incentives. Thank you. With that, I will entertain questions from the audience for the panel. Artie, please.
Quick points. One is for Samuelson and Scotchmer, and the other is a question for Tim Swanson. Too many S names. For Pamela and Suzanne, just the question of national treatment is a little more complicated if one looks at how national treatment actually occurs on the ground. As you might be aware, Kimberly Moore has done some very interesting work on xenophobia in the U.S. courts and how foreign nationals get treated much worse. So I think that may be something you want to bring into your analysis at some point. Obviously, you guys haven't even written the paper yet, so it doesn't. It's a small point. And then for Tim Swanson, I didn't quite understand your third point, which is that you suggested that the biotech industry would be interested in inventing around existing patented positions, and was that? I wasn't clear where they would be. I mean, yes, in general they would be, but not necessarily for developing country research.
Right, not necessarily for developing country research. It's the so-called terminators problem, or genetic use restriction technologies, essentially allowing firms to be able to prevent their biological reproduction of plant varieties that they develop. It's a technology that essentially prohibits or any kind of unallowed or any reproduction.
And you're suggesting that I'm sorry, can you just finish that thought?
It means that you can now enforce intellectual property rights anywhere in the world the way that you want to enforce them. It's no longer a question of whether or not you adopt uniform laws. You can do it biotechnologically.
Mm-hmm.
I want to make 2 remarks, both cautionary nature, addressed to what John Barton was saying and what Samuelson and Susan Scotchmer have been saying. The first, a world patent system. Our world patent system certainly has many advantages, especially it's going to reduce transaction costs for everybody. That's clear. But if you look for the models for such an approach, you would certainly look to Europe. And you would learn from Europe the obvious disadvantages. The European patent system has mainly served large industry, especially foreign industries. It has never served small and medium-sized industry for reasons of access, for reason of the additional cost which you have. The European patent system is based on a convention. It would be the world patent system. Now, the enormous drawback of a convention is that it can never keep up with the technological development. You know that we are struggling with the problem of software patents and biotechnology patents because the technological background of the European Patent Convention is in reality not the 70s when it has been made, but the 60s when it has been conceived of. We are two generations behind. So this is a major problem. When I understand this entire purpose of the conference correctly, then you are looking for better solutions in a world of ignorance, because we have the economists and lawyers tell us we do not know how the patent system really works and how it would be working best. Now, the answer to such a problem certainly is not to unify the ignorance, but to look for better solutions. And the system which we have to find better solutions is competition. So what you would establish rather is, and this is the general objection to any effort of harmonization, is to establish a system of regulatory competition. So you would rather leave national systems than do away with them, or push them to the background. So I would just draw the opposite conclusion from what John Barton has been saying, even if my position, I think, is on the defensive side, and John Barton's proposition is on the forward-moving side, on the progressive side. I think you are in the trend, and I'm against the trend. One additional remark: do not ever believe that you will ever have a review system made of anybody else than patent lawyers. Okay. Second remark. The remark addressed to the problem alluded to by or pointed out by Susan Scotchmer and Samuelson. Yes, but this is an old problem. And we do have the same problem in antitrust law since many years.
Right.
And what has been the result? Take the case like the IBM case in the, when was it, Eleanor, in the 80s?
Yes.
Okay. IBM was not giving information to the producers of peripherals as to the interface. There was a suit in the United States, another one brought in the European community. Now it has been settled in the United States. The European Union was insisting on that pre-disclosure requirement. But would have, if that had been enforced, would have the same effect. Yeah? The pre-disclosure made would benefit to the American producers as well. The American government intervened, of course, as we would if the Americans would try to do that with our industry. So my simple reaction is, your problems will not last very long. Governments will cut it off very soon.
Great.
Yeah?
Oh,
Thank you.
thank you. Would the panelists like to respond to?
We need to identify the speaker. That's Hans Ulrich.
Hans
who's
Ulrich?
speaking later on competition.
Okay.
Was there somebody else who?
Hardy Rye?
Rye.
Right.
Joined
Right.
Someone else.
Okay. No, not yet. But there'll be more. Would the panelists like to respond to any of the points raised?
I just want to say, I think it is an old problem. I think that the expectation by many people was, of course, TRIPS is going to solve that problem, and I think our examples are showing that actually there are new opportunities for things like this to crop up, and that if you end up with, this was my last slide that I didn't talk about because that was not enough time, that what you end up with is if there isn't a use of, say, the TRIPS dispute resolution process to deal with this, which I think that can't be the only solution, or a push to further harmonize down to nitty-teeny little rules so that every rule of every country has got to be the same. I think that's infeasible. And so it seems to me that's infeasible. But then you get back to this effort by national entities that essentially put bilateral pressure on other countries, and that was what TRIPS was supposed to avoid. So I think part of what we're trying to say with the paper is not that this is a totally new problem, but that some of the expectations about how TRIPS was going to solve this set of problems, I think, is over-optimistic. And in some sense, that's a good thing. So in some sense, I think one of the things that I'm going to pick up on one of your comments as to John's paper is that in some sense our suggestions might actually promote regulatory competition that then could give us some additional information about what really promotes innovation as opposed to what doesn't.
Suzanne, you have a few brief remarks. And John, why don't we all try to keep our remarks fairly brief if possible?
Okay, I just wanted to come back to this optimistic view of regulatory competition, which strikes me as really difficult in this domain because of the fact that even though you can have heterogeneity among regions in the regulatory regimes, you don't have heterogeneity among incentives of firms because of national treatment, except to the extent that you have fuzzy enforcement, as Artie points out. So it seems to me the empirical side of that, of trying to make use of the regulatory heterogeneity, is really difficult.
Great. John?
Let me respond to these as best I can. First, the research exemption point is absolutely correct. In fact, your point, one of the ways people solve the research to a problem is go offshore. That's not possible if you harmonize.
Correct.
Therefore, you clearly have to build it in solid. Second, the question favoring small industries, not developing countries. Clearly, if you have a system of this type, you need some kind of fee differentiation structure, just as we have, in the United States system. One of the current problems is that the current developing country scientist has no practical way to apply for a patent in the United States or Europe. So that there are a set of problems of that type that can be dealt with in the overall concept. I think with respect to the review system, we at least have a myth. I don't know whether it's really true, but we have a myth that Congress was that review system about 15 years ago, back when the people in the Senate and House Judiciary Committees really heard from both the consumers affected by an IP system and the people that wanted the benefit of the IP system, and actually sought to build a pretty decent balance. In fact, that's part of the reason the industry went offshore to try to get the WIPO copyright agreement in order to have a stronger political basis to try to get the DMCA through Congress. And so that I think that can be done. Now, the obvious, real, and hard question is, if you globalize it, is it harder to do or easier to do? And I think that's a question that requires a heck of a lot of thinking. I think it's one that people can very reasonably disagree on. And then I guess finally, the one point vis-a-vis the competitive systems. As I suggested at the beginning, it isn't clear to me that the question is between harmonization a la my style and diversity. It is possible that the winning track, whether we like it or not, is harmonization based on an existing U.S. style system pushed through WIPO harmonization negotiations and bilateral agreements.
Thank you, John. The order of speakers, as I've seen hands, are Paul David, Bob Evanson, James Love, and Peter Krause. So first, if we might hear from Paul, please.
Thank you, Wes. Well, all of the really important substantive things that I wanted to say have been now said. I had the similar point about the bias in access to the process in favor of large firms. And I think that is not only illustrated in the case of intellectual property, but when the U.S. reformed its tariff setting procedures, took it out of Congress, put it into the executive branch, there was a market shift in the access which the large firms, which happened to be interested in trade liberalization, had in writing tariff legislation. So there is an issue there. We don't have symmetrical access to the process. More you centralize, even more shit. I won't repeat the other point. I think that the force of your the fifth slide is the point I wanted to say. Look, John, you are playing a high stakes game. You could get points 1 on non-obvious, point 2 on utility patents, and lose point 3. Sure. And the second best solution of leaving this system, which is unharmonized, is safety. If you like, a safety first strategy, which is important. So I'm only left with a question for Wes. Okay. I didn't understand your last remark. Are you suggesting that the Swanson forces try to increase the number of mutant viruses that could attack each research
logical
university's
implication.
Particular domain,
Right.
destroying its local industry or tourist trade, and in that way we would finally solve the problem of the mistake that was made at $5?
No, that's right. No, in fact, I'm surely not. What I'm suggesting is that for better or worse, what seems to move policy are threats that afflict the industrialized world in a fairly salient way, that much for the worse that we've neglected the kinds of policy challenges faced by the developing nations, and that this may be a vehicle to reinforce the public domain that may not only benefit the industrialized nations, but in that process, indeed, also benefit the developing nations as well. That's what I'm suggesting, Paul. But thanks for the, okay. Next, we will hear from Bob Evanson. Yeah, Bob, please.
John, would your world patent system include only one patent instrument? In practice, we've got utility models, which in a sense are almost exclusively national inventor-based. They're suitable for adaptive invention and don't necessarily interfere with a patent system, and clearly would seem to suit a lot of developing countries well. So, are you insisting on one instrument?
I haven't really thought that issue out enough to give you a solid answer. I mean, it's clear, it seems to me that certainly the utility model is an acceptable substitute. There's a strong argument that says that having a patent system is irrelevant for countries below a certain income level. I just haven't thought out what the first level best answers are.
Thank you. Now, we might hear from Jamie Love.
Yeah, there's two different things going on that we see on the intellectual property of globalization. One's this sort of departmentization, right? Impose like a uniform solution for the rest of eternity on everybody, making it almost impossible for people to, innovate in terms of exceptions or things like that. And the other is this sort of private international law mechanisms are trying to push it in the internet context, where you enforce everyone's laws, no matter how ludicrous they are, on everybody, because you just law enforcement and you have kind of just kind of a mindless enforcement of everybody's speech laws, everyone's patent laws, everyone's copyright laws, and try and collect judgments and enforce injunctive relief across borders. I think they're both a really problem. In the Hague negotiations, Michael had a meeting on this, and the proposal we made was that in the old days, the birds were you had mandatory rights that you had to enforce, and you had voluntary exceptions. And the idea was, as John had suggested, your domestic constituency would sort of pick the right balance. You'd have a fight between the right owners and the consumers. And these cross-border transactions, you can really impose the cost of your system on foreigners. So in those kind of situations, the question was, do you really need to have mandatory rights, sort of limits on the rights of the right owner, and sort of flip it around and have mandatory rights for the public? In other words, these sort of, in the internet context, you have to essentially flip on its half before you sort of agree to enforce foreigners' rights on your people. You need some assurances that their rights will be limited in some respect, and that they grant certain minimum exceptions to the public. That was basically the pitch, that you had to flip it, because the nature of the transaction was essentially different. And then one thing that is happening right now, WIPO, was quite extraordinary. I think that the blind have now petitioned WIPO and the Standing Committee on Copyright. Their problem is that copyright exceptions for the blind are territorial and they're national, and they're not permitted to export from one country to the next under the copyright exception. So what they're saying is that if you do a translation or something like that for the blind and a braille product or something in France, you can't then make that available to people in Belgium, even though they speak the same language. You have to recreate the entire expensive process. It's exactly the same thing as the Doha Paragraph 6 negotiations in pharmaceuticals. But in this case, the blind are saying that the exceptions should be mandatory and permit exports for all countries. So what they want WIPO to do is to essentially create mandatory exceptions for the blind that by treaty everybody would have to honor and permit cross-border trade. So it's basically, because they're presenting it among European blind people, nobody automatically thinks as horrifically limited as they do in the paragraph 6 thing with pharmaceutical, to make you stand on your head and, whistle Dixie while you get it or something. So it's an interesting discussion, but I think the jurisdiction issues right now are really sort of a high value added thing, and I'm glad that all these papers are exploring that topic.
Great. Thank you very much, Jamie. The next speaker or discussant, participant here is Peter Charles of Australian National University.
Quick questions to John Barton. I mean, the extent to, there are probably a number of different models of a world patent system. The extent to which any system is feasible, though, will depend on what big business thinks about it. It's clear empirically, if we look at global regulatory harmonisation, it's big business that really determines the pace of regulatory harmonisation in almost every area that I have done work in. So my question is, what is the evidence of big businesses' thinking on the desirability of the world system? It seems to me that big business might take the view there are lots of gains to be had from keeping transaction costs high, because that acts as a barrier to entry, and there's a lot of advantages in the complexity at both a national and a regional level from the point of view of moving assets around. In the same way, for example, that big business resists the idea of a world tax organisation. I suppose there's also a normative argument against a world patent system at the level of patent administration. One would predict that developing countries will resist uniform patent standards by interpreting them at the administrative level in various different ways. And they have sovereignty over how they operate at the administrative level. So in a sense, if a world system were to take away this last reservoir of sovereignty, this could be very undesirable.
John, and after John responds, we will close the session.
Let me take the second one, because it has some twist that I didn't realize until the commission worked. A patent office in a developing country is a profit center. It earns foreign currency and brings in money. Obviously, you're cutting that back, so there are some clear questions. However, if you're going to make a global system work, you really do need appeal, at least of decisions about patent validity and patent granting. The other issue, the big business issue, I think is a really interesting one. One of the things that's in the back of my mind here is trying, in fact, to build on businesses' concerns with the direction the patent system is going. If you look at things like Bob Barr's statement to the Federal Trade Commission Department of Justice hearings, and he is the patent counsel, the patent central officer for Cisco, and saying, in essence, the patent system is a holdup. Industry does not like the way the patent system is going. That's why I'm talking about the position of industry versus the position of the patent bar. And now, it isn't at all clear, of course, that going international is the way to capitalize on that in attempting to reform the system. But I think that's one of the things that we have on our side to help deal with the system.
Great. Thank you very much, John. With that, I'd like to thank our panelists.